All right, my friends. I've never introduced him like this, but like you guys kind of gave him this name. This is Evan Almighty. This is our attorney. This is who I've been talking about. Like I feel like he's not mine anymore. And I'm so grateful that he is here because he has saved me so many times, you guys, mostly because what you don't know, you don't know. And when we talk about copyright, when we talk about protecting our books, it's so important to start understanding because it's not going to go away. So, Evan, thank you for being here.
Thank you for having me. This is awesome. I'm so excited to talk about this, um, mainly because I talk about it every day and I'm happy to share. And I love KDP and I love e-commerce. So thank you for having me. I appreciate it.
Yeah, tell me kind of your background because I've known you for about 4 years now. You helped me about 4 years ago, and I knew you kind of in the space of helping course creators. How did you kind of find that niche of like, I want to help people that are moving and driving and building stuff online?
Yeah, so it's interesting. So I've been a business lawyer for over 15 years. Um, my story is kind of interesting. I won't go into like all the details, but the first 2 years out of law school, I represented banks, lenders, things like that in various business and real estate matters. And then I hated it. So I switched. I was doing small business type work. Um, and a couple years after that, one of my current clients, business partners, was doing Amazon. He had an Amazon agency, and he's like, "Hey, let's just do like, an Amazon brand. We could use it for testing, whatever. If we make money, cool." So we did that for a while, and it did really well. We were selling. They were like large digital clocks for people that suffered from dementia. So it did really well. It got saturated, but I started to get in the space like, as for the business side, but then also started to get introduced to a lot of clients that way, a lot of other small businesses and startups that were in the e-commerce world. And that world just at the time just was blowing up. And since then, it's continued to do that. So over time, over the years, I just had more and more clients that have been e-commerce sellers. So I represent online businesses too, course creators, coaches, things like that. But the majority of my clients now are e-commerce sellers. So anyone from Shopify sellers, Etsy, Amazon, KDP, of course. So yeah, I mean that's kind of how I grew into it. And my little spiel is I help e-commerce sellers with legal protections and strategies to avoid lawsuits and grow their businesses. So that's
I
kind
love
of what
that.
it boils down to.
I love that. The sad part of our relationship is that I found you when I was in a lot of trouble, right? I've shared this story that like I had a book that was trending, it made about 10 grand, and then I got slapped with some type of audit in Amazon where they were like, prove you have the copyright. And I'm like, this is a blank book. Like we cannot actually copyright the inside of a blank book. And so someone had referred me to you and you explained to me that like yeah you can't copyright the inside of a line journal but you have a whole series that's making you money, let's copyright a series. And that really opened my eyes of like oh wow. And from that experience I obviously did not have enough knowledge myself. You helped me through it, I got my account reinstated, but I had to recreate that book again. And we recently had this conversation that like no one really talks about this online and there really shouldn't be any shame about it, but let's dive in actually to the shame of that because I think it cripples us. I think there's a lot of people that are listening today that have lost a KDP account because they didn't know that they could get it turned back on or they didn't know that they didn't do anything wrong. What is kind of your response to those people?
Well, so to to kind of dive into it first, I see that all the time, and um, it's terrifying and it's really frustrating and sad because it also not only does it cripple people at that moment, but it stops them from doing business. Like I've seen so many people that where that's happened, whether it's been a right or wrong delisting or suspension, they'll never do business again and they could have just started and that just stops them in their tracks. Um, but what I say to that is there's two kind of concepts with all IP law, really, copyright, trademarks, patents. But the first thing that we have to make sure of when we're selling anything online is that we have the rights to do it, right? So whatever you're putting in your journals, right, whatever elements from Canva or wherever else you're getting, or if it's your original work, you need to have the actual rights, whether it's a license or somebody gives you the rights to use it. That's the first part. Your book's got to be legal for you to do, and nobody else has to own that, not giving you permission. The second part is, okay, if that's the case, then how do we prevent other people from actually stealing our stuff or selling our stuff or whatever it might be? Or the worst part, which is terrible, is how do we stop somebody else from stealing our stuff and then going and registering the copyright or going and registering the trademark when we actually own the thing? And then they taking our listing down, right? So it's making sure our stuff's legal to use and then making sure it's illegal for anybody else to use. That's kind of the broad picture as to how we're going to look at it. Now, that being said, even if you do all that, you're going to have listings that you're going to have people that come in, don't either intentionally or unintentionally, and file claims with Amazon and get your listings down. But as long as those two pieces are in place, your listing will be able to be reinstated. It might be annoying, but you'll know that you're protected, that you're not, more importantly, that you're not doing anything wrong. You're not violating anybody else's stuff. So I think if you go into it having that mindset, and the problem is, I don't mean to go off on tangents, but the problem is like you don't know until something happens to you. And same thing probably happened to you, Jenny. Like you're nobody knows what it means to get that email, that claim, or worst of all, a lawsuit. And once you get it, it's scary. It's the scariest thing in the world, or not. It's one of the scariest things. Um, and then like you're almost like until you go through that moment, a lot of people just don't understand it. And that's what we're trying to do here too, I think, is hopefully open everybody's eyes, your audience's eyes. And there are quick and easy and efficient and effective steps that we can all take with all of our products to avoid having that worry going into selling.
Yeah. And I think a big topic that kind of stirs the pot for this is AI, right? To be able to use, so the first part is like, I own the copyright because I know I either have the license or this is original work. But what is your advice in terms of being able to register work that has components of AI inside of it?
Yeah, good question. There's a lot of misinformation on this. It's not dissimilar to using like Canva, right? So, um, somebody owns the copyright. Well, let's step back. In order to get the copyright, there's certain elements that have to be there, right? There's got to be the type of work that's protected. It's got to be some literary work, music, sound, video, whatever it might be. It's got to be a specific type of work. The second part, it's got to be original. So somebody had to create the thing and not copy it. The third part, it's got to be creative enough. So I know you brought up like line journals, simple lines in a journal, for example, or simple shapes, simple fonts, like things that are common, Christmas tree. Those aren't creative enough. It just has to be a minimal level of creativity, but those aren't creative enough to have copyright protection. The next element is it has to be done by a human author. So AI obviously is not human, and most of the time when I should say when images are done with AI in today's world, it's at least as of today, the law says that it's not human and you can't get the copyright. Now that has recently changed with the Copyright Office with certain text. There's different requirements, but as far as like images and elements that we're going to put in books, designs, if it's done by AI, it can't be copyrighted. All right. So going back to your question, if you can't copyright that thing, right, can you use it in your overall book or journal or whatever your ebook, whatever you're creating template, and still get the copyright to the entire thing? And the answer is yes. So similar to like Canva, right? As long as you have other elements and things that you've created or that you own, you can get the registered copyright to the entire thing. You just exclude the things that you don't own, like the Canva elements or the AI elements. One thing I do want to bring up, because this is one thing too with a lot of KDP, people that create, or even on Etsy, people that create templates. So website designs or any type of journal templates where you'll have a series. A lot of people think that you can't own the copyright to that if it's basic lines, shapes, and things like that, different designs, but you actually can. So you're not going to be able to own the copyright to the actual content, those shapes, but if you're compiling them in a certain way, in a certain unique and original way, you can actually own the copyright to how those things are compiled, the format, which is super, super effective because if somebody, which we see all the time, takes that format and uses it in journals in different ways or any other KDP books, then you would own the copyright and can get them delisted as well. So super powerful, but hopefully that answered your question with the AI
Yeah.
part.
Yeah, I love that. A good example that comes to mind as you're talking is bullet journals. The
Yes.
gentleman who invented that, he went ahead and he not only trademarked a series of journals in that way, but also kind of the IP around it, that it's actually a methodology and a theory. And that's really what makes copywriting and even trademarking our work powerful, is there are people out there that create incredible things and you should be protecting them online, right? And
Yeah.
so it kind of goes into different conversations. The really interesting thing about what you said is when you upload a book on Amazon, you actually click two boxes. One is that you own the copyright, and then the second is if you used AI. And so a lot of people get confused, like, how can I actually own the copyright and say that I used AI? And I think you've cleared that up for us, that we need to create original work as a full body to be able to register it online. But the Copyright Office is okay with different types of creative elements as part of the overall thing, right? We're not actually using Canva Media Magic to do a coloring page and then taking that color page to the Copyright Office and say, this is mine. That won't work,
Exactly.
right? And so
Exactly.
those are good practices. Any other good practices that come to the top of your mind as we're talking about like using AI in books?
So you froze up a little.
The question was if there's any other best practices that we need to remember about using AI with books.
Yeah, so if we look at, well, both text and images, right? Because we use AI in text. Um, the more you put your creativity and your human touch into it, the better, right? So, and it goes down to prompting, responses, things like that. But at the end of the day, AI, the way that it works, right? It takes other people's stuff as of now, as we know it, and processes it and then spits it out, right? So it's not just, it's taking other people's stuff. It's not just thinking on its own. So we also want to make sure, just for example, if you spit out an image of like some type of heart design, there are ways that we can search to make sure that somebody else doesn't own the copyright to that, right? So like Google Photo, for example, or Google Image. So whatever we're using also from AI, we want to make sure that somebody else doesn't have the rights to that because they're not going to protect you. ChatGPT is not going to say, "Oh yeah, it's our fault. Like we're gonna go to court and protect you." No. So putting it in just some simple Google image search just to double check that somebody else doesn't have it is a really good practice when using AI. And just using it as a tool. Think of it like that. Don't use it to create your entire thing because at the end of the day, you can, right? You can create an entire journal with AI, but what's the point? Right. So somebody can take your entire journal then and also copy the whole thing and sell it and use it and take money out of your pocket because you can't own the rights to it. That's the problem, right? So you want to have that balance of protection, having your rights and making sure that you're, most importantly, that you're able to use the stuff that's in your journal.
I love that. We had a
Yeah.
lot of questions. We had a lot of questions about like when we get in trouble and we get those copyright claim strikes. Um, is the best practice to hurry and go out and register our work, or is it a little too late? Because now, I mean, everyone within the sound of our voice, now they know like once your work is done, go to the US copyright website and pay the 65 bucks and get it. I found another website, it's German, protectyourwork.com. Like, but for people that are now retroactively trying to fix and update stuff, what's the best practice for them?
Yeah, so just to touch real quick before that on the registration part. The good thing about copyright registration is compared to other like legal protections, it's fairly cheap, easy to do. You know, I have a course and step-by-step process on how to do it. That's why I created it, DIY for people that create a lot of content. Um, but you can do before you publish things, you can do up to 10 different pieces of content. I call them content, but like you could do 10 journals, for example, in one 65 to $85 copyright application. So if that's something that interests you and you put it into play, your process, it's worth it to do that. Now, people would say, well, what if it doesn't sell? But what if it does sell, right? So that's on that piece. But retroactively, it's something that's so hard to receive, right? So the first thing is like, if we receive something like that, the first thing I would do is I would question, okay, what's their claim, right? If do I actually have the rights to this thing? Like, where did I get these elements? Like, do I have the licenses, whatever it might be? Because if you do, then you didn't do anything wrong, right? That's step one, making sure that you didn't do anything wrong. If you didn't do anything wrong, then the next step you could think about is, do I do what's called a counterclaim, right? And a counterclaim is just saying, hey, I didn't do anything wrong, right? If you think I did anything wrong, claim it, then you need to prove it and enforce your claim. And the way they do that is by either going to court, or they can, it's the generic term is they file like a small claims action with the Copyright Office, right? So that's the normal process, the DMCA process. A lot of people are afraid to do it because you're like, sue me, right? So it's hard, and if they don't sue you within 10 days, then you get your listing back. But if you didn't do anything wrong, that's usually what I advise. Now, as far as running to the Copyright Office and registering it, you could do that. You could do that. It's not going to do anything as far as that claim necessarily, because that's going to take 3 to 4 weeks anyway. So as far as the claim, it's really not going to do anything. But ultimately, you could do that. Yeah, you're able to register your copyright at any time. It doesn't have to be before you start selling it. It can be at any time. Now, the risk of that is that what if the person, we talked about this before, what if the person that claimed copyright on you actually stole your stuff, but then went to register the copyright before you did, right? What do you do then? You're not going to fight that. It's going to be too costly. And people do that. That drives me nuts, but people do that all the time.
Well, and
Uh,
you had a client that
oh,
happened to, right? Somebody recently stole her content, then they registered it, and then she had to litigate to
yeah.
try to prove that she was the original owner of it.
Yeah, and it's super hard to do. Like the old school way to do. We didn't used to have to register copyrights, but now it's like you hear this, prove it, prove it, prove that you own it. And I say it too. If you don't have the registered copyright, how do you prove it? Right? They used to be like they used to call it I think the poor man's way to know. They would literally like put something
Mail it
on
to yourself.
paper,
Yeah.
yeah, mail it to yourself, and that would do it, right? So yeah, I mean, there are ways that we can prove like when we actually did it, but it's super costly, super, timely, and it's just usually not worth it. But registering copyright has a ton of other advantages, right? So in order to sue, you need to register copyright. You get statutory damages, which is just you get absolute money from it. It puts people on notice. Again, you could just say, here's my registration, like it's a thing. If you have to file these claims with Amazon or Etsy, whoever, you're supposed to have the register. Sometimes they accept not registered copyrights, but you're supposed to have the actual registration. So it's hard for somebody to say that you don't own it if you have the registration.
Do you think that some of those big billionaire companies are kind of lenient on that? Let's take my example, for example, that someone's had a pending trademark, but it wasn't live and they weren't even using it correctly. And they were able to file a third-party claim and get my account suspended. Um, this happens so much that I'm like, first of all, people shouldn't have shame around it because I wasn't doing anything wrong. But then the second part of that is like, I also see the power of being protected, like this company that filed for the trademark. But is there any type of immoral side of that? Like they shouldn't be going around and doing copyright strikes when it's not live. The second part of this, which is kind of a long tangent, but Amazon will not get involved in third-party claims for whatever reason. And so that leaves a lot of KDPers, a lot of self-publishers exposed to know what to do and what not to do. And I share that because I've shared emails with you of people that have done copyright strikes where they're asking for very personal information inappropriately. They want to know how much I made. They want the money. And you're like, this is absurd.
Mhm.
And so talk to us a little bit about like navigating that or knowing kind of the best practice around that. Because without you, I would be like, I have to do this stuff because I don't know the law.
Yeah, I mean, it's scary what people ask for. Like, I mean, they're scams, really. For the most part, they're scams. Like, so going back to like the morality of it, yeah, I mean, so in your particular case, they filed a trademark application. They haven't even used the name yet, number one, right? So
Only in
that's
a title. Only in a title. Yeah.
only a title, but yeah, so they don't own the trademark yet. They haven't even started using it as a trademark yet. And when they do, they won't even be using it as a trademark anyway. So yeah, it's well, is it illegal? Maybe, but it's for sure immoral what they're doing, what other people are doing. And unfortunately, there are companies out there that like they'll just file the trademarks in that sense for that purpose. And they can just keep extending the application and extending the application and just trying to be the number one seller for that key term. It's terrible. It's a very immoral way to do things. Is it illegal? Maybe. Could you stop them at some point? Yeah, but again, it's terrible. So in that case, like you didn't do anything wrong, right? So you did everything that you were supposed to. But best practices when you get a letter, take it's I see these all the time, so it's easy for me to say. But again, these things are like scary. And when you got it, Jenny, you knew right away. But like you're like, what? These are detailed letters, and why are they asking me for all this stuff? Do I have to give it? And the answer is, unless somebody with authority, like the court, right, requires not even Amazon because they don't have the authority, but like the court requires you to give that information, then don't give it. I think that's the best practice. Like, no, so it's easier said than done, but and obviously consult with a lawyer if you're really worried about it. But no, you don't have to do that unless the court of law requires you, and there's a court order, and it's a
Yeah.
process.
And I think that's why sometimes these really big publishers do that. If they can get your personal information, then they can subpoena you. They
Yeah,
can send you something, right? So I understand also I mean, I have 96 pen names. So like someone's not going to be able just to message me or send me something in the mail. The unfortunate part about KDP is that if someone feels like they are infringing, we can't really do a cease and desist unless this person's building a social media thing off of it and we can get in contact. So that suspension is almost like Amazon has no choice but to take a step back and let you litigate or at least conversate. But that doesn't necessarily mean that one, you did anything wrong or that you owe that third party anything, as Evan said. So I think that's really, really good clarity.
yeah.
Um,
It really comes down to like before you're hitting publish, making sure that I say ducks in a row, but just making sure you have the legal rights to use whatever's in that thing. If you do, then there's even if somehow like you were sued, you will not get in trouble because you didn't do anything wrong, right? And that's like that to me is the peace of mind that goes into it. So even if somebody claims or files a claim and they try to get you suspended, you can file a counterclaim because even if they did sue, which the likelihood of them doing that because of the cost to do that is insane compared to what the value they would get potentially is, you're protected knowing that you didn't do anything wrong.
yeah, yeah.
Um,
And
so
we've even kind of ideated on like what is the best thing for this when someone is not using trademark properly and you see the opportunity to do so. Like I very well could use that keyword and go build out 5 books in 3 days because I'm that fast.
mhm.
And then come back and say like, no, sorry. But finding out that this person did it to somebody else in the KDP space, I'm like, I don't even want to deal with this, if there's a chance to repeat. But that being said, this is someone that is not publishing in the United States. What is good tips? Because our community is kind of all over the world, especially uniting here on this channel. What is the best route for someone that's in the EU or in a different country? Should they be responding and honoring US law first because Amazon is a US company?
Yeah, I mean IP law, it's where you're selling, right? So if they're selling on Amazon US, then you have to respect the US law, but the US laws apply, same thing. So it doesn't matter. I mean, everybody's remote now. The internet's everywhere. Who knows where people are selling when you go on a URL, right? Um, but it doesn't matter where you're located, it matters where you sell your stuff. So you have to abide by those laws. So United Kingdom and Australia, most countries, to my knowledge, have very similar copyright laws in a sense that the protections there's different processes in place, but really, if you're selling in those countries, you should know what those laws are versus what they are in the United States and what you can and cannot do. So if you have a copyright to a journal in Australia, you don't have one in the United States. If you start selling in the US, you could potentially get one, but like you just need to know the differences and educate yourself.
Those are all really, really good tips. So as a self-publisher, like moving forward, what is the best way for someone to work with you? They should have some, I mean, it just depends, right? Because we know we can trademark a series of books. You've also taught me today that we can actually copyright the interior of low content books if they are unique enough, right?
Mm-hmm.
We can trademark a pen name. We've talked a little bit about that, and we can trademark our publishing name. Out of those three things, what do you feel like is the best next step for someone that's listening and wanting to protect their brand on Amazon?
Yeah, so it really depends kind of what you're selling. So on the trademarking side, trademarking is different than copyright. Trademarking, it protects anything related to your brand. So your slogan, your titles if they're a series, your pen names, which is to me that's a brand name, or it could be a company name.
Yes.
Anything that somebody's like, oh, I see that. I'll use Harry Potter for example, like the Harry Potter series, like that's a brand. Like I know that goes with Harry Potter. Um, if you don't have a series and you're doing single books, which is normal, you cannot own and protect that title with a trademark because it's not considered your brand. It's a one-off title, which makes sense. That's why if you could see title, like there's a lot of similar titles of books out there, and you probably wonder why, but that's why. Now a series is just two books though. So if you're really like Jenny teaches you how to spit out very effective books that make a lot of money. You could do two, right, for every series. And if it's something that's really selling, then it might be smart to register the trademark because then there was the keywords and things like that. So that's the branding side. The copyright side, so I do for my services, I do trademarks on a project by project basis. So there's a couple step process. The first thing is, can the name even be protected with the trademark, right? Is it generic? Is the book title like this is a book, for example? So it has to be unique enough in order to get a trademark. If it is, then the most important step is making sure that there isn't the same or similar name out there selling the same or similar products, which are the books, right? If somebody is using a similar name and they're selling similar products to books or books themselves, then you won't be able to use that name. So that's where we would get in trouble. That's the most important step. You want to make sure you're not violating somebody else's trademark. And then if all that clears, then it's doing the trademark application, filing it with the USPTO, and waiting. It takes about 12 to 15 months or so in today's time frame. Ours are usually like 9 months, 9 to 10 months, our applications, but the average are like 12 to 15. Um, so we do those one off, but whether you hire an attorney to do or hire another service to do the trademark, if you're going to use, especially a series, because if you use a single title, you're not using it as a trademark and you can't get in trouble. But if you're going to use it as a series, you definitely want to make sure you're doing a comprehensive search. And I can send you my checklist on that too, Jenny, if you want to give the audience, but
Yeah.
making sure that nobody else has the similar name selling similar products. So that's a trademark side. On the copyright side, um, in an ideal world, I would tell you to register the copyright to all your works if it's copyrightable. If it's original type of work, not done by human author, those things. Um, that costs money. That's a process. So in reality, that won't happen. But maybe your bestsellers, you do that, right? Or maybe every couple you do that. For me, I do those project by project basis, but I also have a DIY mini course that Jenny has that she can give out. But those are different scenarios for the copywriting and the trademarking that for my services. And then I also have a community, I'm revamping right now. There's a wait list. It's called Pocket Counsel. Super excited about that, and that's stay tuned for that. But
And that's potentially a membership where people can come
yeah.
in and like learn about trademark, learn about copyright, and just get their business, their book business, kind of their affairs in order, right? So they're protected, but then also I love what you kind of talked about, that like using the law is a defensive mechanism, but an offensive mechanism too. And if we can lead offensively, we're going to be in a better position. Something that I've been coming up with a lot is there are a lot of people that do low content, and Amazon doesn't allow us to make them a series if they're repeated pages. So it kind of made me wonder if there was any room for us to work on a project for my best-selling books to get the interiors copyrighted as low content books and then submitting it to Amazon where they would actually let us combine it as a series. So that could be interesting, because I remember a couple weeks ago you told me like Amazon can't decide what is a series, but they do because they have their own platform, right? But that isn't, I don't think they're speaking legally. So really, really, really good tips. So we're going to put the link for the wait list below for anyone that's like copyright curious, which we all should be, right? Because if our books even made $5, we should, it's not a lot to go do that. Any other takeaways that you want people to remember? And can you just talk about like getting over the shame of this, that like it doesn't have to be scary? I mean, even
Yeah.
you share that recent email of like, because for me everything is really retroactive, it's been retroactive, and I don't love that. I don't love that, oh my gosh, it's my account suspended or it's terminated or I have to figure this out. I recently learned that like if we do trademark and Amazon knows about it, they treat us a little bit more professionally too.
Yeah, well, to hit on that really quick, having these on the offensive, having these protections in place, trademarking, copywriting, besides the peace of mind, there's stats out there where, on, at least on the trademark side, if your business has a registered trademark, you grow 14 times faster than those that don't. Now, a lot of that's probably mentality and that you might be like quote unquote serious about your business, but it makes sense. And these are on the offensive, they're big monetary gains for your business, not only in the sense that you can stop other people from stealing your customers, and they don't just steal your customers, but it's the main thing is it's your reputation, right? So if they copy your journal and somebody's like, I'm gonna go purchase Jenny's journal, right? And they end up on the listing and they think they're purchasing Jenny's journal, but they purchased Bob's journal. And Bob's journal is not what they thought it was. It's crap, like whatever it might be. Then this person might be like, well, Jenny stinks. And I'm gonna tell all my friends that Jen don't shop at Jenny's listing. So it's not only just one listing and one particular journal, it could be your entire business. So that going all that offensive and stopping people from doing that is a big monetary thing. Um, so that's a huge deal. As far as like the embarrassment thing, I mean, it is really tough. I see it day in and day out. I mean, the reason why, and this is one of the reasons I got into this business, not only because everybody's so creative and everybody has a different business, and it's the reason why I do what I do. Like I work remote, I spend more flexibility to do things with my family, like my own entrepreneurial journey. It's the same thing as most e-commerce sellers and KDB sellers. Um, it's disheartening and it's frustrating to see that um, the embarrassment, because once that happens, once something happens to them, they won't share it and then they won't sell again. And the reason that we're doing this is to have that freedom to help our spouses, whatever it might be, and to have it like stop us in the tracks, which is all the time. Um, it is tough to see. So it's the reason why we're doing this, Jenny, why we're trying to say it's okay. And you just did it on your channel, and you're a veteran and one of the most experienced sellers I know, not only just KDP but e-commerce and in the business online world. And it happens to all of us. And like I said, I mean, I shared you the email that happened to me, the same thing, like it admitting where we were wrong and being vulnerable and being able to share these things. We're all here. It happens to us all.
Yeah.
But we're trying to stop it. Trying to stop it and trying to give you the weapons and the tools to give you that security that if something happens, you can stop it.
Yeah. I think that I love what you said because of what you taught me when my account was terminated and reinstated in the copywriting series, I went on to do similar books that went on to surpass those books.
That's awesome.
And so it's kind of like life is not linear, business is not linear. It's going to be up and down, just like an ads account. But no one can take away the skill set that we have as course creators. And no one, we can always create something that didn't exist before, right? So it's like anyone within the sound of our voice, like if you've lost your KDP account, it's not the end. Like you have a skill set to go out and do more. And there's lots of different mechanisms to be able to do that. But I really appreciate the empowerment that I got by hiring an attorney to give me the clarity that like, no, you have good stuff and you don't have to give up and you can keep making money. And I think that's one of my favorite things about you as an attorney is like, you're in the trenches too. And so I'm going to drop Evan's YouTube channel below because he publishes too, right? Like anything I told him, like, start talking about copyright and books. Like we need all the help that we can get. But I think that's a really important part is don't go out and hire your cousin's brother's friend that does family law. If you need trademark or copyright, like use someone that's in the space that gets it. And for me, that's you to see you're posting, you're growing your online business. It makes such a difference because you know the IP laws. So I'm so grateful. And I feel like we're going to have more conversations like this because there's so much integratedness, you know, with like protecting
Yeah.
your content as course creators.
Yeah. And then, well, and that's one of the big pieces of Pocket Counsel, which I'm revamping, is my regular Zoom Q&As for stuff like this. So having an accessible method um, where sellers aren't afraid to ask questions, or whether they could just listen to other people's questions, because we're all in similar boats for the most part. Everybody has specific situations that we all need to deal with, but just knowing that there's a community and answers to solve your specific situation right away will hopefully be reassuring.
I love it. I love it. Thank you so much for your time coming
Yeah.
on. I'm going to drop the freebie links below and we'll have a wait list for Evan's membership, which is coming up, which is really great. So thank you guys so much.
Thanks. This is awesome, Jenny. I appreciate it.